name is Oshinaike. My name is Olariwaju Oshinaike.
For the claimant, right?
Yes, my lord.
And the claimant.
My lord, and I also have my friends with me, two of them.
Okay.
Wale Adeshola and Raphael Ipiyomi. They are with me for the claimant, my lord.
Yes. Who appears for the defendant?
My lord, I appear for the defendant, Oluwasegun Otebola.
All right. Thank you.
My lord, there are also appearances for Oluwole Olatunji Kolade. I think my microphone was muted.
No, hold on first. Decisions. Present C. Hold on, gentlemen. There are 5 judgments to be delivered today.
Yes.
Right? So just hold on for the court to call out your own specific matter. Okay?
As the court places.
Yes. For Oluwole Olatunji Kolade and ITF and 2 others.
Okay.
My lord, Louis Akanimo appears for the claimant.
Claimant, yes.
And my learned friend Bayo Yusuf also with me. The claimant.
Claimant, right?
Yes, my lord.
Good. Who appears for the first and second defendants?
Mr. Monan is on the is showing that he's here.
Yes.
Sorry, my lord, my name is Mike Monan. Sorry for that. My mic was muted. My name is Mike Monan for the first and second defendants, sir.
That's fine. Then, Mr. Chibuze, you all have for the third defendant, right?
Yeah. Yes, my lord.
All right. Can you gentlemen please mute your mics while the court reads out its decision for this matter?
As the court pleases.
As the court pleases.
Thank you, gentlemen. Now, so this is the court's decision. I'm going to read through. Now, the claimant commenced this suit on 27th of April 17 by an amended statement of facts filed on 15th of January 2019. Claimant seeks the following relief against the first and second defendants and other compelling defendants to immediately pay over to the claimant the sum of 82,830,000. Mute your mics, please, gentlemen. Mute your mics. Now, the claimant commenced this suit on the 27th of April 2017 and by amended statement of facts filed on 15th of January 2019, claimant seeks the following reliefs against the defendants. 1, and other compelling defendants to immediately pay over to the claimant the sum of 82,830,973 naira 94 kobo, only being the outstanding arrears of unpaid pensions owed the claimant from 1st May 2002 to 31st March 2017. B, and other compelling the defendants to pay the claimant the sum of 12,888,140 naira 54 kobo only as annual pension from 1st of April 2017 until such a time as salaries and or allowances of 7 staff are reviewed upwards by the defendants or until the federal government of Nigeria approves a direct increase in pension. C, post-judgment interest on the said sum of 82,830,973 naira 94 kobo only at 10% per annum reckoned from the date of judgment in this suit to the full and final liquidation of the defendant's outstanding indebtedness to the claimant. The first and second defendants entered appearance on the 21st of June 2017. I will leave of the Honorable Court file this consequential amended defendant's statement of the first dated 1st of February 2019. By an order granting the third defendant leave to be joined as a party to the suit, the third defendant filed his statement of defense dated 5th of February 2019. At trial, claimant testified as CW, adopted his deposition on oath, and 21 documents were tendered by the claimant and admitted into evidence as Exhibit C1 to C21. He was cross-examined and therefore discharged. Claimant then closed his case. On behalf of the first and second defendants, Suleiman Ningi testified as DW1 and Abdullah Shehu testified as DW2. They adopted their respective depositions on oath, and 10 documents were tendered through DW1 are marked as exhibits D1 to D10. Both DW1 and DW2 were cross-examined and thereafter discharged. The first and second defendants then closed their case. The third defendant opened his defense and called one Adihiogu Anselm Chiadi, a deputy director and acting director of compensation department, who testified as DW3. He adopted his deposition on oath. 6 documents were tendered through DW and admitted into evidence marked as exhibits D11 to D16. He was cross-examined thereafter discharged. Third defendant then closed this case. Parties were then ordered to file and exchange their respective final addresses, which were adopted on the 25th of May 2022, and judgment was then reserved. I'll summarize the case before the court and the submissions of the defendant in final address, as well as counsel to the claimant in final address. Due to time constraints, I'm just going to go straight to the court's decision. Now, I've carefully considered all the processes filed in this suit, as well as the arguments of counsel. In this court's opinion, the issue that arises for the court's determination is whether or not the claimant has proven the quantum of the reliefs claimed. This issue subsumes and adequately addresses all the issues formulated by learned counsel in their respective final addresses. In labor matters, the claimant is obliged to show an entitlement to the monetary reliefs and how he arrived at the quantum. Mr. Mohamed Dungus and ELL Consortium. Now, in NICA, the citation provided. Now, in NICN/LA/60/2015, claimant successfully established an entitlement to an upper review of his pension. The claimant, however, did not in that suit lay claim to any specific amount or percentage of the increase due to him, which led to the institution of this suit. I've noted the objections of the learned counsel to the first and second defendants in his first issue for determination to the effect that the claimant was litigating in installments, and on that basis, the suit ought to be dismissed. I've considered the authority cited by learned counsel to the first and second defendants in support of his position, and I find that those cases were not decided within the same context and circumstance as this instant case, and therefore not applicable. An authority must be considered within the context of the law and the facts the case is to be applied to before applying same. The case is only authority for what it decides. PDP and INEC and Zuwuji and APC, where Idris citation provided for these matters, and where Idris JCA emphatically held thus that, and I'm quoting his lordship, it is not settled law that cases are decided on their peculiar merits, and a case is only an authority for what is decided. See generally Nigerian Ajib Oil Company versus Inquiry, citation provided, and Interdrill Limited and UBA PLC, end quote. Further, in law, context is everything, as Lord Stern succinctly put it in R versus Secretary of State for the Home Department's ex parte daily, citation provided. The court will therefore discountenance the objection of the learned counsel to the first and second defendants on his issue 1 and resolve the issue in favor of the claimant. It's also appropriate at this stage to deal with the other preliminary objection raised by the learned counsel to the first and second defendants with the admissibility of exhibits C10, C6, C10, C12, and C20 on the grounds that they are public documents and did not meet the conditions prescribed for the admissibility of public documents as per in Section 90 of the Evidence Act 2011. I've considered the respective arguments of counsel in support of their respective positions on this objection. While I do not agree with the claimant counsel that an objection on the non-certification of public documents is a flippant one and ought to be dismissed out of hand, I must consider the special statutes of the National Industrial Court of Nigeria and the rationale behind the establishment of the court, where public documents are in custody of the claimant's adversary, and the only copies available to the claimant are uncertified copies, which documents are critical to the just determination of the issues between the parties. Should the court then close its eyes and determine the rest of the parties without such critical evidence, would that be justice at the end of the day? I think not. All issues must be resolved without technicalities, and justice must be seen to have been done. This is precisely the rationale behind Section 12(2)(b) of the National Industrial Court Act 2006. I am mindful of the long list of authorities, Ogunle State, Obian State, and Aboaba, was a Ogundipe citation provided for these matters, that have held that only certified true copies of public documents are admissible in evidence. However, as stated earlier, a case is only authority for what it decides. Given the peculiar status of the National Industrial Court, these authorities were not interpreting the powers of the National Industrial Court specifically admit uncertified copies of public documents, and so can be distinguished from these authorities. I am also aware of the Court of Appeal decision in the case of SEC vs. Abilo Owobisu, unreported suit number CA/A/380/2013, where the court explicitly held that the NICN is bound by and must follow the provisions of the Evidence Act 2011. However, in the more recent 2022 decision of Mr. Victor Adeboyu versus UBA, unreported suit number CA/IL/20/2021, delivered on the 14th day of April 2022, the Court of Appeal clarifies its position on the powers of the NICN to depart from the Evidence Act and held as follows. I'm quoting his lordship now. I must use this opportunity to state clearly that this court, in the case of Sec versus Abilo Wobiso, suit number CA/A/380/2013, judgment of which was delivered on 21st of December 2016, did not invalidate or diminish in any manner or form the provisions or intendment of Section 12(2) of the National Industrial Code Act 2006. In that case, Sec versus Abilo Wobiso unreported suit, the National Industrial Court admitted in evidence public documents that were not certified on the grounds that Section 12(2) permitted the court to depart from the Evidence Act. The Court of Appeal held that the provisions of Section 12(2) of the National Industrial Code Act 2006 cannot operate to encumber the provisions of the Evidence Act 2011. Part of the reasons upon which this court based its decision was that the Evidence Act 2011 was made by the National Assembly subsequent to the National Industrial Code Act 2006. However, in that case, the attention of this court was not drawn to the following facts. Firstly, granted that the Evidence Act 2011 is in the explanatory note as well as in Section 256, made it clear that the Evidence Act, in repealing the old one, shall apply to all judicial proceedings in or before all courts in Nigeria. Section 4.2b of the Interpretation Act, Cap 123, LFN 2004, provides that where an enactment is repealed and another is substituted for it, then any reference to the repealed enactment shall, after the substituted enactment comes into force, be construed as a reference to the substituted enactment. It shall be noted by Section 1 of the Interpretation Act. The Interpretation Act shall apply to the provisions of any enactment, except insofar as the contrary intentions appears in this act or in the enactment in question. Secondly, I beg your pardon, gentlemen, give me a second, let me close the door. The noise is coming in. Sorry, it's raining here in Abuja, so the noise of the rain is coming in. I beg your pardon for that. Now, secondly, Section 2 of the Evidence Act 2011 provides that for the avoidance of doubt, all evidence given in accordance with this section shall, unless excluded in accordance with this or any other act or any other legislation validly enforced in Nigeria, be admissible in judicial proceedings to which this act applies. The provision to Section 2 provides that the admissibility of such evidence shall be subject to all conditions as may be specified in each case by or under the Evidence Act. The implication is that Section 2 acknowledges that there are existing laws that exclude the application of even the Evidence Act 2011. Thirdly, Section 3 of the Evidence Act 2011 provides that nothing in this act shall prejudice the admissibility of any evidence that is made admissible by any other legislation validly enforced in Nigeria. Therefore, if any legislation makes any evidence inadmissible, the intention of the legislation in that regard must be respected, meaning that Section 3 must be read to mean nothing in this act shall prejudice the admissibility or otherwise that's the inadmissibility of any evidence that is made admissible or inadmissible by any other legislation validly enforced in Nigeria. Fourthly, Section 12(2) of the National Industrial Act 2006 is not delimited by time or date. It talks of Evidence Act and not Evidence Act 1990 or Evidence Act 2004. Therefore, the notion that the Evidence Act 2011 is subsequent to the National Industrial Code Act 2006, that is because the National Industrial Code Act was passed in 2006, it cannot be said that the Evidence Act 2011 was contemplated under it, cannot really hold ground, as the National Industrial Code Act 2006 simply talks of Evidence Act. Even if Section 12(2) of the National Industrial Code Act were delimited by time or date, Section 4.2b of the Interpretation Act took care of the problem. With very due respect, had the attention of this court been drawn to the foregoing factors, certainly this court would have held otherwise. Therefore, I maintain that Section 12(2) is extant and applicable at the National Industrial Court. In view of the foregoing, I hold that Section 12(2) of the National Industrial Court Act 2006 ought to apply to this case and is hereby applied. The lower court ought to have departed from the provisions of the Section 84 of Evidence Act 2011, which is hereby departed from. Consequently, the order of the lower court discountenancing and expunging the said Exhibit VG14 is hereby set aside. The said Exhibit VG14 is to be given its probative value. The issue is consequently resolved in favor of the appellant. End quote. Now, I'll just finish citing His Lordship Amadi JCA in the UBA matter, right? Now, there's no quagmire here in the above decisions of the Court of Appeal, as there's an established principle, as the established principle of law is to follow the latest decision. See the case of Znet Singapore Limited versus Mofas Fishing, where Iezuba JCA held, and I quote, the law is well settled that where there are two or more conflicting judgments, it is the latest in time that must be followed. See Sterki and Solam, Ikenia Infamo, Ikeawu versus Wangpa, Osakwe and FCA Asaba. Citation provided for all these matters and end quote. The question is this a deserving case for the departure of the Evidence Act from the Evidence Act 2011? I believe so. Now, pursuant to Section 12(2)B of the NICN Act 2006, I therefore depart from the Evidence Act 2011 and find that in the interest of justice, Exhibit C6, C10, C12, and C20 are hereby admitted into evidence as exhibits and would be considered in the determination of this suit and as a whole. Now, the question before the court is which of the two competing computations of the quantum of the claimant's entitlement is the correct one. This suit stems from a letter from the third defendant and the federal government white paper reference number AFNC 862376 dated 7th October 1997. The court in NICN/60/2015, I beg your pardon, had ordered the first and second defendants to review upwards the pension of the claimant as salaries were being reviewed at the first defendant. There was no yardstick specified to be used in the upward review. The court, however, made it clear that the first defendant was to review the claimant's pensions as he did salaries and allowances for his employees. The claimant here has put forward several computations in his various exhibits, but the pertinent computation is the one stated in his reliefs. The issue here with the calculations is that the claimant is not at liberty to ascribe percentages or figures as he deemed as his entitlement, and expect either the defendant or the court to accept without a proven and sound basis for these calculations. It has also been shown that the third defendant here has and retains the constitutional duty of determining pensions of former employees of the federal government or federal government bodies like the first defendant. The claimant cannot rely upon the declaration in 60/2015 or Exhibit C6 to usurp the powers of the third defendant and as a whole. Which brings me to Exhibit C6. While it is admissible and was admitted into evidence by the court, its evidential value is entirely it's another matter entirely. I've closely examined this document. I find that there's nothing on its face that confers an absolute entitlement as to the percentages or the figures sought here on the claimant. The claimant was to forward his calculation of the arrears of his pension to the first defendant to, quote, serve as a guide for the fund's internal analysis, end quote. This statement shows that in this court's considered opinion, that the first defendant needed to conduct an analysis of the claimant's calculation before a final resolution of what is to be paid to the claimant. Exhibit D2, D3, and D4 all show the processes leading up to the increase of the claimant's pensions by the first defendant, having considered the input of the claimant and the body statutorily empowered to determine pensions in Nigeria, the third defendant. Exhibit D7 shows payment to the claimant that resulted from the processes of the defendant. The issue now is, have the first and second defendants complied with orders of the court in LA 60/2015? After considering the circumstances of the case and the evidence placed before the court, I've come to the firm conclusion that the first and second defendants, acting on the advice and guidance of the third defendant under its constitutional powers, have complied with the orders in NICN/LA/60/2015. I am also satisfied that the defendants have acted within the ambit and confines of the law in the computation of the claimant's entitlements as shown in paragraph 31 of the deposition of A.S. Ningi, which was pleaded in paragraph 40 of the conspiracy statement of defense of the first and second defendant filed on the 1st of February 2019. I am satisfied finally that this computation represents the quantum of the claimant's pension entitlement and as a whole. Accordingly, there exists no grounds for the grant of the relief in this instance in view of the court's findings above. I therefore release all the reliefs sought here and dismiss all the claimants' reliefs. Parties are to bear their respective costs, and judgment is entered accordingly.
As the court pleases.
As the court pleases.
As the court pleases.
You can pick up on Monday in Lagos, gentlemen.
As the court pleases.
As the court pleases.
I'm much obliged for the well-considered decision of this court.
Thank you, Mr. Kanyip.
Yes, my lord.
I wish you a good vacation, Mr. Omona.
Very well, sir.
Very well, my lord.
Mr. Father is very excited.
Yes.
We are grateful. We are very grateful, sir. As we said, it's a judgment in realm, and others were waiting. We are grateful, sir.
All right. Thank
We
you.
are we are grateful, my Lord.
Enjoy your vacation.
Thank you,
Thank
my
you, my
Lord.
Lord.
I'm much
Thank you, sir.
obliged.
Thank
We are
you, sir.
very much obliged, sir.
Thank you. Chief Paul and Okonga Ejekere. I see you're both online.
Yes, my Lord.
What of Mr. Usiolaputi? Is he with us?
Let me see.
I don't see Mr. Kuti on the platform. It's possible it's one of the phones that do not have a name attached to it.
Yes.
Well, anyway, for 426-2017, Chief Dr. Peter Omojiade and Chief Paul Omojiade and Mr. Peter Idigbe, right?
Yes, my Lord.
Chief Paul appears for himself.
Yes, my Lord.
Stephanie Okonga Ejekere appears for second and third claimants.
Yes, my Lord. As God pleases.
Who appears for the Mr. Kuti is here, is not here, so who appears for the defendant? Not here? All right, this is the court's decision. The claimant commenced this suit by general form of complaint dated the 7th of September 2017 and filed on the same date and sought the following reliefs. There are a total of reliefs numbered A to H. For time constraints, I will not read out the complaints here. The first claimant abandoned relief E sub 3, that is for the refund of deducted loans. Similarly, the second claimant also abandoned relief E3, which is also for refund of deducted loans pursuant to the decision of the Supreme Court in Lewis versus UBA, the decision of Ojili JSC as he then was. The defendant entered appearance and joint issues with the claimant, and the matter was set down for trial. At trial, claimant called 3 witnesses. They adopted their respective depositions on oath, and 37 documents in the total were attended by CW1 to 3 and admitted into evidence and marked as C1 to C37. All witnesses were cross-examined and discharged, and then the claimants then closed their case. On behalf of the defendants, 1 witness testified as DW, adopted the deposition on oath, and 31 documents were attended through this witness and admitted into evidence as D1 to D31. DW was also cross-examined and therefore discharged. Claimant, defendant then closed his case. Parties were then ordered to file and place respective final addresses. And here we are. A judgment was then reserved. I've summarized the crux, the case before the court, the submissions of the defendant, the final address, and the submissions of the claimants as well. The decision running into almost 40 pages, so I'll not read all. I'm going straight to what is important, which is the court decision here. So I've carefully and dispassionately evaluated the evidence placed before the court and assessed the processes filed in these proceedings. In determining the issues between the parties, the court will adopt the issues formulated for the court's determination by the claimants. I'll start off with the determination of the preliminary objection raised by the learned counsel to the defendant. This preliminary objection was filed by the defendant on the 5th of May 2022, seeking an order of this honorable court declining jurisdiction to hear and determine the suit for being incompetent. This objection was premised on the ground that the claimants ought to have filed a separate suit as they do not have a common grievance and interest against the defendant. Though this application was filed at the close of evidence when the matter was adjourned for adoption of final addresses, the defendant was within his rights to do so. It is tried that the issue of jurisdiction can be raised at any time or even for the first time on appeal. See the case of the state of Onagorua, victim of OSJSC as he then was. Now, in this instant case, counsel to the defendant placed heavy reliance on the authority of Just Self, Enugu, and others vs. Chevron, and government of Akwa Ibom State and Ayawung, Joshua Matthew, and others, citation provided for these matters. This instant case can clearly be distinguished from the above authorities, as the claimant here are not suing in a representative capacity, and from the process filed before this court, each claimant has a defined but identical grievance against the defendant. In this court's considered opinion, a resolution of the first defendant's grievance against the defendant, first claimant's grievance against the defendant, would have a determining effect on the other claimant's cases. It is therefore the position of the law that where issues are so entwined, they constitute a common interest. Not only should the claimants file a common action against the defendants to enable all the parties save time and cost, it is also prudent to do so to avoid a situation where contradictory decisions could be given by the same court, on the same facts, same grievance, and same documents. The claimants, despite having individual contracts, have all based their grievances against the defendant on the trust deed and the defendant's policy, which they contend shall change them in the payment of their existing entitlements. In addition, the claimants did not contend that they are placing reliance on the specific terms of their letters of employment, neither did they contend that they were employed on the same day. Exhibit C1, C4, and 17 and other documents of the defendants add a document that apply to the issues between the parties here and call for the court's interpretation of its application to the claimants. I therefore find that this action is not incompetent. The preliminary rejection is hereby overruled. In determining the issue one as formulated by the claimants, Leonard counsel to the defendant contended that the claimants ought to have joined Union Trustees Limited and William Street Trustees as parties in this action. I have already summarized the submissions of counsel earlier as such, there will be no need to rehash. The first question that arises here is, can the issues between the parties as constituted be resolved without the presence of Union Trustees and William Street Trustees? I find that the answer to this question is in the affirmative. The claimant placed before this court Exhibit C15, C26, and C37, which clearly show the defendant making calculations and payments that gave rise to this suit. There was no reference in the affirmation exhibits to either Union Limited or William Street Trustees. Exhibit C37 in particular stated on its face that the payment of gratuity was calculated in line with the bank's policy. There is no claim against the two trustees, and the matter can be determined without their presence in this court's opinion. At this point, reference has to be made to the case of Eco Bank versus Idigbe. ECPA held as follows: that the law is certain that a necessary party is one whose presence is required for the effective and efficient determination of the suit. The necessary party must be one against whom the plaintiff has a claim. End quote. I cannot agree with the argument of the defendant, with the defendant counsel in paragraph 4.05 of his final address, that where there's any short payment of the gratuity made to a former employee, it is the trustees that will be in a better position to resolve the dispute. The contractual relationship that existed between the claimants and the defendant. The contractual relationship that existed was between the claimants and the defendant. Exhibit C4 has the defendant and the two named trustees as the parties to the deed. If the defendant was convinced that the dispute could only be resolved with the presence of the two trustees, on the premise that it acted on the advice of the trustees on what the entitlement of the claimants were, then it was incumbent on the defendant to apply to the court to join the two trustees as parties to this suit. The defendant failed to do so, and the court can rightly conclude that this issue is an afterthought intended to be a clog in the wheel of justice. I therefore find that the proper parties are before the court on the basis of Exhibit C15, C26, and C37, which give rise to this suit. The defendant's objection on this ground is also overruled. Before delving into the merits of the contentious issues, reliefs sought by the claimants here, the first and second claimants had in paragraph 1.03 of the claimant's final address withdrawn with 3E Roman numeral 3 for the refund of deducted loans pursuant to the Supreme Court authority of Lewis and UBA citation provided. Accordingly, Relief 3 Roman numeral 3 as sought by the first and second claimants are hereby dismissed. Now, issue 2 as formulated by the claimants is whether or not the first claimant's resignation or retirement was voluntary. The first claimant here raised dispute issues in Kano State, where he was transferred to and the alleged victimization meted out to the first and second claimants by the defendant in transferring them to branches headed by sub-managers as the reason for their exit from service of the defendant. I have considered the arguments for and against this contention. What immediately comes to mind is the glaring fact that the first and second claimants here have not shown why they were allegedly victimized. There must be a reason for this alleged victimization. The defendant had given reasons for the transfers in the statement of defense, which seemed plausible to the court. This is in addition to the fact that the first and second claimants cannot pick and choose where to work. The first and second claimants, as part of the terms of their employment, were not promised to remain at any particular region or state. At least this fact has not been shown to the court. Were the defendant's employees in Kano branch where the first claimant was posted to somehow immune to the alleged insecurity that the claimant insisted was so prevalent as to constitute an attack on the court psychological contract. The first claimant cannot rely on the newspaper clippings to justify his refusal to be transferred to Kano. If there were any incidents that affected the staff at the Kano branch of the defendant bank that could rationalize the claimant's fears, then it should have been placed before the court. Then again, the claimant expected the defendants to lead evidence as to the practice of posting managers and sub-managers. However, counsel forgot that it is he who alleges that must prove. Besides, the defendant had averred that the position of a business development manager is headed by a senior manager and not a sub-manager as alleged, which contention was not countered by cogent and compelling evidence by the claimant here. It is he who will fail if no further evidence or any evidence is adduced on either side that bears the burden of proof. On the whole, I'm not satisfied that the reasoning proffered by the first and second claimants meet the minimum threshold of proof on the balance of probabilities that they were victimized or forced out of employment by the defendants. This especially as the first and second claimants had not stated that they were leaving for any other reason except for what was on the faces of their resignation letters. The transfers to Kano and Ado-Ekiti were at different times, and the first and second claimants left the bank at different times. The decision to seek to leave years after their respective exits was nothing more than an afterthought. Accordingly, I find that Relief 3 is unproven and is hereby dismissed accordingly. Coming to issue 3, the contention of the claimants here is that they were shortchanged in the payment of their gratuities. The issue here is what constitutes total emolument of the claimants under the 1996 trust deed. Counsel to the claimants had referred the court to Mrs. Omain Lily Uyo and Union Bank PLC and CEO Kiki and 2 others was the Union Bank PLC. Both decisions of this court on the definition of what constitutes the total emolument under clause 20 of the trust deed 1996. In Mrs. Omain Lily Uyo, this court held thus, and I'm quoting here, in resolving the issue of the operative deed applicable to the case of the claimants, the court would examine the circumstances of the entire case. The defendant in paragraph 4.13 of the final address stated that the claimant was paid more than what she was entitled to in accordance with the 2004 trust deed. The question is why? Is there a legal basis for this gesture, or is the defendant a Father Christmas? The learned counsel to the defendant argued that on the strength of Exhibit C2, the claimant was only entitled to 48% of her total emolument. I find this act of the defendant illicit. I'll return to this later. Again, the claimant, whoever has the Infinix Hot 8, please mute your mic. Again, the claimant had listed a number of cases wherein the defendant had relied upon the 1996 trust deed, even after the 2004 trust deed had presumably come into effect. The only response from the defendant was that the pleadings in those cases were not placed before the court. The counsel should know that this court can take judicial notice of his own decisions, particularly where citations are provided, which brings me to why the learned claimant counsel failed to draw the court's attention to its own decision in 160/2017 CEO Kiki and 2 others versus Union Bank PLC, which decision was delivered on the 30th of June 2020. This court specifically examined the 1996 and 2004 trust deeds of the defendant bank and held that the trust deed of 1996 is more credible and believe that it is the document that is operative and applies to the claimants. I end quote. I hear in this instance, I find that the above decisions of this court in Lily, Omain, and Okike Supra are applicable here. I adopt my findings and conclusions in the aforementioned suits and find here that under the 1996 trust deed, the claimants are entitled to total emolument as defined under clause 20 of the 1996 trust deed. I find further that the claimants are entitled to the payment of gratuity as provided under the scale of amounts receivable based on the percentage of the employee's annual total emolument as set out in the schedule attached to the deed of the relation trust deed 1996 and also hold. The total emolument therefore due to the claimants is as determined by a community reading of clause 20 of the 1996 trust deed and paragraph 18, page 15 of the 1996 trust gratuity rules. I also agree with the claimants that the case of Martin Schroeder was Major and Company, citation provided, applies here. The specific provisions of the gratuity rules 1996 must prevail here. I am therefore satisfied that the claimants have successfully established their entitlement to reliefs for the shortfall in their gratuity and therefore entitled to respective sums are set out as gratuity shortfall in relief E and particularized in paragraph 11C and 12 of the deposition of the first claimant, paragraphs 12 and 13 of the second claimant's deposition, and paragraphs 10A and 13 of the deposition of the third claimant. As a whole, the defendant is hereby ordered to pay the first claimant the sum of 19,068,000 naira as the shortfall in its gratuity. The defendant is also ordered to pay the second claimant the sum of 18,607,500 naira as shortfall in its gratuity. Finally, the defendant is hereby ordered to pay the third claimant the sum of 1,022,810 naira 11 kobo as the shortfall of his gratuity. Coming to relief for deduction of allowances by the defendant from the entitlement of the claimant, the defendant has failed to place before the court any policy that justifies such deduction. Clause 10 of Exhibit C22 certainly does not grant the defendant the right to make such arbitrary and unilateral deductions under any guise. I also agree with the claimants that Exhibit C15, 26, and C37 cannot operate retrospectively and justify these deductions. A similar issue was dealt with by this court in Omain. And I also find solace, Omain Supra, and I also find solace in the persuasive decisions of Malana Brothers, OO, Oyeumi J in Idigbe and Union Bank, citation providers, and Peters J in Omole and Main Street Bank, citation also provided, which the claimants cited and agree are applicable to this suit. I therefore find the deduction of these allowances from the entitlements of the claimants was unlawful, and hereby order the defendant to refund to the first claimant the sum of 1,441,141 naira 44 kobo, to the second claimant 5,135,891 naira 44 kobo, and to the third claimant the sum of 1,112,500 naira as wrongfully deducted allowances from the entitlement. The defendant cannot exploit its dominant position over the claimants and take such unilateral and costly steps as expected to be endorsed by the court. Now, for the 13-month payment, the court is bound to follow the persuasive precedent of Peters J and registered trustees of Union Bank Pensions Association was UBN PLC, where his lordship held that the 13th month was not ex gratia, as it was a product of negotiation, adopt his lordship conclusions and further find that not being an ex gratia payment, it is therefore an entitlement that can be enforced. As so whole, the claimants have showed evidence of being members of the claimant union in RTU BPA was UBN Supra by the payment of their union levies in Exhibit C26, C16, and C36. This was not contested by the defendant, and the claimants are therefore entitled to benefit from the said decision. As so whole, I am also not swayed by defendants' arguments and reliance on the Pension Act, Reform Act 2004, as the basis for the flawed calculation of the 13-month entitlements of the claimants. There's nothing as contained in the Pension Reform Act that forbids the payment of 13 months or entitles the defendant to use the 2005 emoluments of the claimant as the basis for the calculation of the claimant's 13-month entitlement. Accordingly, the court finds that the claimants are entitled to 13-month, particularized in paragraphs 26, 43, and 56 with the statement of facts, and therefore order the defendant to pay the first claimant the sum of 1,796,624.7, second claimant the sum of 1,822,108.13, and the third claimant the sum of 143,064 naira and 74 kobo as the shortfall in the 13th-month payment. The claimant's case therefore succeed in the following terms. Reliefs A, B, and D hereby succeed and are declared as paid. Relief C is refused and dismissed accordingly. Relief E only succeed in sub-relief 1, Roman numeral 1, Roman numeral 3, Roman numeral 2, and Roman numeral 4 for the first claimant, and sub-relief Roman numeral 1, 2, and 4 for the second claimant, and sub-relief 1, 2, and 4 for the third claimant as well. Sub-relief 3 having been withdrawn was dismissed earlier on by the court. All awards have been complied within 30 days of today, for failing which they will attract 20% simple interest until liquidated. If therefore succeeds to this extent. I will not refer to any Uzo citation provided, where the apex court held that unlike special damages, which must be specifically pleaded and proved strictly, the quantum of general damage not need to be pleaded or proved, and the manner in which the general damage is quantified is by relying upon what a reasonable man's judgment will be in the circumstance. Also, F. Petroleum was Umar citation provided on its part held that general damages is at the discretion of the court. I am convinced that the actions of the defendant was unjustifiable and exploitative of his dominant position over the claimants. General damage should naturally flow from these wrong actions of the defendant. Court therefore awards the sum of 1 million naira in favor of each claimant as general damages to be paid by defendant for his wrongful actions, making a total of 3 million naira to be paid within 30 days as general damages, failing which it will attract 20% simple interest until liquidation. Parties are to bear their respective costs and judgment is entered accordingly.
As the court pleases. We're most grateful, my lord. And we're
Welcome.
very grateful for the well-deserved judgment.
And you won now.
Thank you, my lord.
It's always well considered when you win.
No, not exactly, my lord. It was
Mr.
very
Obi-
your time.
Thank you. Thank you.
Judgment. Thank you very much, my lord.
Thank you for Mr. Obinai, Islam, and EcoBank. Do you have counsel?
Yes, my lord. Counsel for the claimant is present, holding the brief of Solomon
Imosemi. Solomon
Yes,
Imosemi.
yes, my lord.
And for the defendant? Any appearance for the defendant? Well, there's no appearance for the defendant. The court will proceed to read his decision. Claimant commenced this suit on the 11th of June 2019 against the defendant via the general form of complaint and statement of facts. The claimant's claims against the defendant are as follows. The sum of 7 million. Mr. Imosemi, well, the sum of 7,078,416 naira 67 kobo. The said sum represents the claimant's terminal benefit and entitlement from the defendant bank for 9 years and 8 months, a period when the claimant was in the employment of the defendant. The claimant also claimed interest on the said sum at the rate of 20% per annum from January 2016 to final liquidation, and also cost of the suit. Summarize the case before the court and the submissions of the parties, and I'm in final address. And this is the court's decision. I've carefully considered the contentions of the parties and evaluated evidence placed before the court. I'll start off with a statement of what facts have been established to the court's satisfaction. The claimant was in the employment of the defendant. His employment was governed by the terms and conditions as shown in the exhibits before the court. The claimant's employment was terminated by the defendant that stated that the claimant's services were no longer required. It is important here to know that no other reason was given for the termination of the claimant's employment, and one cannot vary the contents of a document by oral evidence. I've studied a number of cases on this. In addition, the words in a document must be given their literal meaning unless it will lead to an absurd interpretation. I find that this is not the case here. The ordinary and literal meaning of the words contained in the termination letter must be ascribed to them and are so whole. Flowing from this, the question before the court is, can the words of the termination letter be taken to mean that the claimant's employment was terminated for gross misconduct? I think not. The defendant had a choice as to state clearly that fact, if that is what it intended to convey, but it did not. Now, neither the court nor the ordinary man on the street is clairvoyant as to read minds and ascertain hidden meanings, thoughts, or intentions. This is important as the wording of the termination letter carried critical consequences for both parties. From my own understanding, the defendant could have ended the employment contract for disciplinary reasons. Where this option was taken up by the defendant, it was not obliged to pay the employee any of the exit entitlement. However, the defendant, in the exercise of his rights under the employment contract, decided to simply terminate the employment contract for any other reason except for disciplinary reason. It is bound to pay the exit entitlements. Sorry, I take that again. Where the defendant, in the exercise of his rights under the employment contract, decides to simply terminate the employment contract for any other reason except for disciplinary reasons, it is bound to pay the exit entitlements of the employee. Now, it's also clear, and it's also been established before the court, that the qualifying period for gratuity is 10 years of service in the defendant's employment. However, there's a proviso to this that said that this payment of the exit entitlement can be made on a prorated basis where the employer has spent less than 10 years. Specifically, clause 11.2.4b of Exhibit C2 provides, and I quote, EcoBank may wish to terminate the employment of an employee in his best interest and in sole discretion without being required to disclose the reason, unless specified otherwise by country legislation. In this case, the affected employee shall be given 1 month notice in writing of such decision, or be paid 1 month salary and benefits in lieu of notice, together with the entitlements and benefits due to the employee under the gratuity scheme or separation scheme in place. These entitlements will be prorated for the number of years of service. The minimum period of service required under the scheme will not apply in this case. In case of group management or executive, the notice will be 3 months. end quote. It is because considered opinion that clause 11.2.4b of Exhibit C2 applies to the claimant's case. The defendant did not, from the face of Exhibit C5, state any disciplinary reason for the termination of the claimant's employment, and this court would not, despite disputed efforts of the defendant counsel here to convince it otherwise, conclude that services no longer required can be interpreted to mean a dismissal or termination for disciplinary reasons. In this court's considered opinion, this phrase simply means the defendant has no further need for the claimant's services. The defendant may have had a need for the claimant's services when it employed him, but given that for whatsoever reason now he does not want the claimant to render those services any longer, when the defendant is desirous of the termination of the claimant's employment to come under clause 11.2.5 of Exhibit C2, it will have clearly stated so, not to leave that fact to conjecture or speculation and as a whole. On the face of Exhibit C5, it's clearly stated that the claimant was entitled to 1 month's salary in lieu of notice. This certainly would not have been the case if the termination was meant to come under clause 11.2.5 of Exhibit C2, which provides that no notice shall be given where the termination of appointment is prompted by a serious offense. If the defendant cannot appropriate and reprobate at the same time, it cannot contend that the termination was for misconduct which carries no notice and yet give the claimant 1 more notice. As the defendant expressly stated, the claimant's service was no longer required. It must then be construed in actually its own best interest as envisaged by clause 11.2.4b of Exhibit C2. It is therefore baffling that the defendant elected to pay the prescribed salary in lieu of notice to the claimant, but evade the latter part of the entitlements of the claimant under clause 11.2.4b of Exhibit C2, which says that the claimant shall be entitled to the entitlements and benefits under the gratuity scheme on a prorated basis, and parties are bound by their contracts. The defendant is bound to comply with the terms he drew up and agree with the claimant as governing the employment relationship between the parties, and as a whole. I have therefore come to the irresistible conclusion that in the context of Exhibit C5, the claimant's employment was terminated under clause 11.2.4b of Exhibit C2. The claimant is therefore entitled to his prorated exit pay as provided under the said clause, as he had not attained the 10-year threshold for full payment and so forth. This, especially as clause 11.2.4b of Exhibit C2 makes the termination at the behest of the defendant exempt from the 10-year prescribed period for entitlement to gratuity. This is the scenario in this case, and the parties are bound by this. Clause 10.8.32 of Exhibit C2 cannot apply to the claimant here, as Exhibit C5 does not state that the termination was for disciplinary reasons and so forth. I also find that the defendant cannot enter the answers elicited from the claimant in the course of cross-examination to contend that the claimant's employment was not governed by Exhibit C2. One cannot by oral evidence verify the terms of a contract or a document. See, I've cited a number of cases here. Exhibit C1 provides on page 2 under other conditions that, and I quote, medical facilities are provided up to a set limit. This and other conditions shall be enumerated in the company's handbook, end quote. The defendant has not denied that Exhibit C2 is his handbook. The defendant went further to tender this same document as Exhibit D3, and therefore satisfied that Exhibit C2, which was tendered as D3, represents the operative handbook that governs the employment relationship between the parties and so on. I am, however, in agreement with the defendant that the claimant did not particularize how he arrived at the sum of 7,078,416 naira as his gratuity. This, being in the realm of special damages, must have been specially pleaded and should be proved. The claimant has not done this here. In labor relations, claimant seeking monetary relief is obliged to prove an entitlement and show how you arrive at the quantum paid. See Dungus and General Consortium and others. I am therefore satisfied that while the claimant has proven his entitlement to the gratuity, but this is only the first leg. The claimant has not proven as to how he has arrived at the quantum of 7,078,416.67. The court cannot therefore make this award. This is not a situation where the court can, by way of consequential orders, order the defendant to calculate and make the payment of the gratuity because the claim is circumscribed by the relief claimed. The only relief being sought here is for the payment of it. And since it has not been, the claimant has not complied with the rules of special damages, unfortunately, the court cannot make such an award. So unfortunately, the court cannot make the award, cannot grant the relief sought by the claimant, and this case is hereby dismissed. Judgment is entered accordingly. Parties are to bear their costs. Mr. Emosemi.
Yes.
Yeah,
I was very upset with you.
I'm sorry, my lord. I was held up somewhere. I called the registrar.
No, it's not about you being in court, right?
Yes, my lord.
It's about your reliefs. You only wanted the payment. You did not tell the court how you arrived at the 7 million. It's special damages. I found that he's entitled to the gratuity. I don't know what he will do from moving forward. He's entitled to it, but I don't know how you arrive at 7 million, because the gratuity payment can be 70 million. It can be 3 million, but you need to show the court and then prove to the court how you arrived at the 7 million. And by not doing that, I cannot grant it, unfortunately. You will have a copy by Monday, so you can proceed from there.
As a copy, please.
Thank you, gentlemen. Mr. Chukudi Eze, I've noticed you've been here for a while.
Almost grateful, my lord. We're always happy to be before the court.
Yeah, your matter is Mr. Ngadi.
Yes, your
lordship. I'm here, equally here.
Mr. Ngadi Emmanuel Ogechi.
Yes, my lord,
Right?
I'm here. I'm here.
My lord,
Mr.
I'm also
Ohamo.
here.
Mr. Ohamo, CM Ohamo is here.
My lord, I'm also here.
Who represents the party? Who represents the parties, please? Let me have appearances.
CC Amasike for the claimants, my lord.
CC Amasike.
For the claimants, my lord, I'm here. Yes, sir.
Yes, please.
Your
Then
lordship,
for this.
Chukudi Eze for the first and second defendants.
All right. Thank you, gentlemen. Oh, where is your file? Now, this is the court's decision. The claimant's reliefs against the defendants are as follows. The total sum of 44,204,216 naira 8 kobo, being the short payment of salaries as an assistant banking executive for 12 years, retirement benefits as an assistant banking executive for 17 years of completed service, arrest of salary as assistant banking executive for May, June, July, and August 2018, and general damages. They were particularized, which was what I was referring to, Mr. Imosemi to. They were particularized. The reliefs are on the face of the pleadings, right? Now, I've also summarized the case before the court, and gentlemen, I'll give you indulgence to just read the court decision, right? Now, having carefully evaluated the process filed in this suit alongside the submissions of counsel, as well as the evidence placed before the court would adopt the issues for determination as formulated by learned counsel to the defendants. They are: 1, whether the claimant is vested with the local standing to commence the suit against the first defendant for the alleged wrong termination of the defendant, having regards to the absence of the claimant and the first defendant, and 2, whether the claimant has proven his entitlement to release claim in this suit, having regards to the pleadings and evidence before this honorable court. Gentlemen, give me a minute. Let me check my system.
Copy.
Need to.
Sorry, gentlemen. Now, starting with issue number 1, Exhibit C1 shows the claimant was employed by the second defendant on the 5th of October 2000 and immediately seconded to the first defendant. It specifically provides that, and I quote, "You will be employed as a driver on secondment to Fidelity Bank PLC," unquote. The wordings here are clear and devoid of any ambiguity. The claimant therefore contended that his salaries were paid by the first defendant and the second defendant is affiliated with the first defendant. The first defendant, on his own part, argued that the first and second defendants were separate legal entities, and it was the second defendant who employed the claimant, which is the same as Exhibit D1, that the terms of his employment with the second defendant were clearly spelled out in the said Exhibit D1. Defendant contends further that there is no privity of contract between the claimant and the first defendant, and consequently, the claimant lacks the local standing to sue the first defendant, who is a stranger to the contract of employment, even if the contract was made for its benefit. That the fact that it pays salaries to the claimant did not create an employment contract between the parties. The first defendant here claims that the claimant was never a member of his staff, but rather a member of staff of the second defendant, and there was no cause of action against the first defendant, which translates to no local standing against it. Accordingly, the first defendant prayed the court to strike out the claims against him. Now, the question to ask would be, what evidence has the claimant adduced in support of his contentions that they have the right to sue or other contract of employment with the first defendant? What evidence has been presented before the court to show the terms and conditions of any relationship between the claimant and the first defendant? I've carefully gone through all the processes filed in this matter and could not find any evidence in support of the above. It is the law that once the party asserts, he or she must prove. Section 131, 1 and 2 of the Evidence Act 2011 and allegation of saying is citation provided. The need for proof by evidence is there is an unequivocal admission of material facts. Perhaps, as I may as well add that once cogent evidence is led by who you asserts, the burden of proof is shifted to the one against whom the claims have been made. In the instant case, the first defendant has denied being the employer of the claimant. The duty and burden is on the claimant, therefore, to show by cogent and compelling evidence that the first defendant indeed was his employer, or the existence of a contractual relationship between the claimant and the first defendant that gives him the right to sue. It is the party that will fail if no evidence is adduced, that must adduce evidence, the convincing evidence of that fact that needs proving. See the case of Madam Sarah Oscar and other versus Malan Mansour Ali Isa, as well as Amici and INEC, Dowdo and NPC and Fashano and the core association provided for all these matters. Here, the claimant has placed reliance on Exhibit C1, also Exhibit D1. Exhibit C1 is the letter of employment and was signed by an Emeka Obiagu for Fidelity Union Securities Limited. Exhibit C1 clearly spelled out on page 2 that, and I quote, "Your employment will be governed by the Fidelity Union Securities Limited regulation and conditions of service enforced from time to time. Please sign a duplicated copy of this letter to indicate your acceptance of this offer of employment, appointment, and return same to us within 5 working days," end quote. On the same page 2, there's a column for the signature of the same Emeka Obiagu, who signed Exhibit C1 for the second defendant for the claimant to sign indicating his acceptance of the offer of employment and the terms and conditions attached to it. Clearly written on the said column is the claimant's name, Mr. Emmanuel Ngadi, followed by a signature and the date 9/10/2000, which is within the 5 days prescribed by Exhibit C1. Employer, the column for employer reads Fidelity Union Securities Limited. Now, it is elementary and parties are bound by their contract, and not even the courts are allowed to make contracts for the parties. The party is also bound by the contract if he entered into. There's no doubt in my mind that the claimant knew precisely who the other contracting party was and what terms and conditions were attached to the contract. The court would accordingly discountenance the various arguments and submissions of the claimant that he either protested against being employed by the second defendant, or that there was a disguise in dealing with him in the course of his employment, and as a whole. There's also no dispute between the parties that Exhibit D1 and C1 was issued to this claimant by second defendant. It therefore follows that the two parties to the contract of employment are the second defendant and the claimant, and as a whole. At this point, I also refer to the holding of George Rose JCA in the court of Onano versus Union Bank, where his lordship held as follows, and I'm quoting his lordship here: "A person such as the appellant in the instant appeal would have no locus to enforce a contract to which he is not a party, and thus lacking any privity of contract, either with the respondent or the federal government." See Prince Alabi Alabi, Shitu, Ogunlowo, and others, where ONUJC had emphatically pronounced that in law, there's privity of contract, and it's always between the contracting parties who must stand or fall, benefit or lose from the provisions of their contract. Their contract cannot bind third parties, nor can third parties partake or accept liabilities under it, nor benefit thereunder. End quote. I also refer to Motec Investment Limited and other versus Odema citation provided, where EDJCA also stated that the doctrine of privity of contract simply says that only parties to your contract can sue, be sued, and be liable and in the event of a breach. In the Supreme Court case of United Bank for Africa and other versus Alhaji Babangida Jargaba, it was held that the doctrine of privity of contract is all about the sanctity of the contract between the parties to it. The doctrine will not apply to a non-party to the contract who may have unwittingly been dragged into the contract with the view of making him a shield or a scapegoat against the non-performance by one of the parties. Also in Ogundari and another was Ogunlowo, ONUJCA held that in though there's privity of contract, it's always between the contracting parties who must stand and fall, benefit or lose from provisions of the contract. Their contract cannot bind third parties, nor can third parties take or accept liabilities under it or benefit thereunder. End quote. It was, end quote. It was the second defendant by Exhibit D10 that terminated the appointment of the claimant here. This exhibit was signed by an Odion Akim on behalf of the second defendant. So the question is, if the same party that employed the claimant also terminated his appointment, where does the first defendant come in to be sued for wrongful termination as the claim? There's no evidence on record to show the existence of a contractual relationship between the claimant and the first defendant to justify the relief sought against it. Exhibit C7, C9, C10, C12, C13, C14, and C22 are not proof of a contract of employment between the parties over the terms of C1. Even when the claimant was described as, quote, a staff of the first defendant, it is not sufficient to hold that he is employed by the first defendant in the circumstances and context of such description. It is also not in dispute that as at the date of such description, the claimant was on secondment to the first defendant. So within that context, the court finds that the mere description of the claimant as a staff of the first defendant is not sufficient proof of the existence of a contract of employment between the claimant and the first defendant, especially as the claimant has not placed anything further to prove the existence of a contract between him and the first defendant and so on. Now, Exhibit D14 and D21 are the Personnel Policy and Procedure Guide, PPPG, of the first defendant of the 2017 version and 2015 version, respectively. I've closely examined the PPPG with a view to seeing if the terms and conditions stated therein are applicable to the claimant. 3.1 of Exhibit D4 and D21 PPPGs both provide, amongst others, that employment to the bank is subject to the various conditions and rules and regulations set out in this guide, including any form. Generally, it wishes to employ qualified staff to approve positions under contracts of service. And on page 9 of both exhibits D14 and D21, clause 3.11, it states that the contract of service is an agreement between Fidelity and the employee, specifying the terms and conditions of service and the effective date on which the employer has been engaged by Fidelity. The contract of service includes a conflict of interest clause, which must be separately signed by the employee. Both parties then sign the contracts of service. For either Exhibit D14 and D21 to apply to the claimant, he must lead evidence to show that there's a contract of service between him and the first defendant, which shows the date of engagement, as well as the other conditions set out in the PPPG. I've gone through each and every clause in the PPPG, and there's no mention at all of staff on secondment like the claimant here, simply because in the court's opinion, they are not members of staff of the first defendant, and there was no intention of extending the provisions of the PPPG to individuals who are not under a contract of employment or service duly executed by the first defendant and the employee. And therefore, find out that the first defendant PG to apply this matter on the scene, especially as Exhibit D16 shows that the refusal of the first defendant to convert the claimant. It shows the refusal of the first defendant to convert the claimant into his employment proper. If the claimant had at any point believed he was employed by the first defendant, as he argued, there would have been no need for Exhibit D15, which led to Exhibit D16. Accordingly, in the absence of any preview of contract shown between the claimant and the first defendant, I find that the claims against the first defendant in this claim are incompetent and I hereby struck out. The lists are only maintainable against the second defendant, who was the employer of the claimant and as a whole. Coming to the reliefs against the second defendant, the claimant had a duty to establish a right to this claim. He who approaches the court has the duty of proving the entitlement to relief sought. Both case law and statute support this proposition. See Chairman EFCC and another versus Solicitor General and another, except in citation provided. Except in relation to express and unambiguous admission, the burden of proof remains on he who was said. However, even if a defendant does not enter an appearance or does not call witnesses or lead evidence at trial, that does not confer on the claimant an automatic entitlement to judgment. The law remains the same, that he who asserts has the burden of proving the assertion. Here, the contract of employment of 5th of October 2000 is the bedrock and foundation of the contractual relationship between the second defendant and the claimant in this employment relationship. Others versus LSDPC citation provided. The terms and conditions of the employment are before the court as Exhibit C1 to enable the court to determine the rights of the parties thereunder. The law is right that parties to a contract are bound by the express terms and conditions as clearly stated involuntarily entered agreements unless there is established evidence that the party was led into an agreement fraudulently or deceitfully. Chidoka was the first finance company limited citation provided. In event of disputes. Now, before this court is Exhibit C1, which is the letter of employment of the claimant with the second defendant. The emoluments and entitlement of the claimant under the contract are stated on page 1 of the C1, which come up to about 145,000 naira per annum. I've also considered Exhibit D22, which provides for the emolument of an assistant banking executive. Now, given that Exhibit D16 had refused the plea for conversion of the claimant into the first defendant's employment proper, there must be some evidence shown to the court's satisfaction that the claimant is entitled to emolument shown in Exhibit D22. D22 was not addressed to the claimant, so where is the proof of it applying to him or the evidence of entitlement to the provisions? Being in the realm of special damage, there must be specially pleaded and should be proved. The court cannot simply take his word for it that the claimant was an assistant banking executive and as a whole. I must note that the words ABE, that the letters ABE appear under the claimant's name in Exhibit C9. But it would amount to speculation, which the courts are not allowed to make, to assume what ABE means. In the absence of a document categorically promoting the claimant to that position, the court cannot conclude that the claimant was ever an assistant banking executive and so whole. As a consequence, I find that the claimant has not shown an entitlement to the payment of 4 months arrears of salary as an assistant banking executive, while the claimant has not shown an entitlement to that salary scheme, and the alleged short payment of salaries probably from leave one of the main claim, hereby refused and dismissed accordingly. Leave one, hereby refused and dismissed accordingly. With no wrongdoing established on the part of defendants, I find that there are no grounds for the award of damages. Leave two of the main claims also refused and dismissed accordingly. Coming to the alternative reliefs, the law is that the court may only consider the alternative reliefs where the main reliefs are refused. Relief one of the alternative is hinged on the defendant's PPPGs tendered as D14 and D21. As earlier held, these are not the PPPGs applicable to the claimant by virtue of the C1, which clearly states that the first defendant's terms and conditions are those that are applicable to the claimant. The second defendant's terms and conditions are those that are applicable to the claimant. There is nothing before this court to show that the first defendant's policies are those applicable to. There's nothing before this court to show that the first defendant's policies are those that are applicable to the employees of the second defendant. In any event, by Exhibit D2, the first defendant sees the gratuity scheme under which the claimant based this relief. This head of claim is not therefore grantable and as a whole. The second defendant had terminated the claimant's employment as at May 2018. The employment came to an end on the 4th of May 2018. How then can the claimant make a claim for salaries for the month of May, June, July, and August 2018 when he was no longer in the second defendant's employment? Accordingly, this court finds no obligation on the part of the second defendant to pay the claimant this head of claim for arrest of salary and so whole. With no wrongdoing established on the part of the second defendant for the relief so dismissed, the claim for the relief for damages must also fail, hereby refused and dismissed accordingly. On the whole, and for the avoidance of doubt, the claimant's case fails and it's hereby dismissed in its entirety. Parties are to bear the respective costs. Judgment is entered accordingly.
We're most grateful to your lordship for the well-considered decision. We are most grateful, your lordship.
Thank you. God willing, it will be ready on Monday. If it's not ready on Monday, check on Tuesday.
As the court says, we are grateful, your lordship.
Thank you. For Mr. Mojid Adekunle Akindele versus Lagos Building Investment Company.
Yes, my lord. My lord, my name is Olaniwaju Oshinake. I'm here, and I'm here with my friends.
Oshinake. Yes.
Oshinake, yes, my lord.
Yes.
I'm here with two of my friends. My lord, my name is Olaniwaju Oshinake, and my learned friends, Raphael Ipiyomi and Wole Adeshola appears with me for the claimant.
Yes, please. Who appears for the defendant?
My lord, my name is Oluwasegun Otebola, and my appearance is for the defendant.
Yes. This is the court decision.
The transcript. TJ is our owner. Can you hear from there?
Can you mute your mics, please, gentlemen? Please mute your mics, gentlemen. Now, this is the court decision. The claimant commenced this suit by way of a complaint and accompanied by other origination processes and by its amended statement of facts filed on the 11th of April 2018, seeks the following reliefs against the defendant. A declaration. There are 7 reliefs being sought here. But I'll go ahead and read it since it's the last judgment for today. A declaration that the purported disengagement of the claimant as company secretary from the service of the defendant by a letter reference number LBIC/ED/OPS/admin/HR/0036/16 dated 26th of June 2016 on the directives of executive government of Lagos State is in breach of the provisions of and the company's employer handbook to the claimant for the service of the defendant on the allegation of fraud, gross misconduct, disobedience, and dispute without the opportunity to defend himself. The allegations is in breach of the fundamental and therefore unconstitutional, unlawful, and wrongful. 3. Declaration that the claimant is entitled to his unremitted past pension contributions, which as of June 2017 stood at 2,882,353.870 to such amount as the money may appreciate in value and until judgment is delivered. General damages in the sum of 10 million naira in favor of the claimant against the defendant for the unlawful and wrongful termination of the claimant's employment as the company secretary / legal advisor of the defendant. Interest on the general damages of 10 million naira at 10% per annum, and special damages for unpaid salaries and allowances from May 2016 at the sum of 133,100 naira 91 kobo per month to judgment. Interest on special damages at the rate of 10% per annum, the sum of 5 million naira being the claimant's solicitor's fees and cost of this action. And I've summarized the case before the court. Claimant being a legal practitioner was employed by the defendant as a legal officer sometime in 2002. I've made the summary of the case before the court and the submissions of the defendant in final address as well as the claimant in final address. And I'm going straight to the court's decision. I've read all the submissions of counsel and the processes filed in this matter. I've evaluated the oral and documentary evidence presented by both sides. In determining the rights of the parties in this suit, the court will adopt the issues for determinations formulated by the claimant. I would, however, start off with a pronouncement on the admissibility of some of the documents admitted into evidence by the court in the course of trial. The court had directed parties to raise any issues as to the admissibility and evidential value of these exhibits in their respective final addresses pursuant to the provisions of Order 15 Rule 4 of the National Rules 2017. And the case of Nwabioku versus Nwodi, citation provided. The learned counsel to the defendant in arguing the first issue formulated for the court's determination raised objections to the admissibility of C3 and C4, which are the defendant's board resolution dated 19th of December 2012 and from CAC 2.1, the particulars of a person who is the company secretary, respectively. These objections were on the ground that these exhibits were public documents within the definition of Section 102 of the Evidence Act 2011 as amended and were not certified true copies as required by Section 104 of the Evidence Act 2011. The rationale for the mandatory certification of public documents as certified true copies of public documents as a condition precedent to its admissibility has been judicially considered and stated in Oboru vs. Odua, also Uzuma and Asodiki, right? Now, I'm mindful of the long list of authorities, right? Ogunle and State, and Obi and State, and Baoba and Windipe. I've heard that only certified true copies of public document admissible evidence. I have carefully considered the respective arguments on this objection and closely examined Exhibit C3 and C4. There are stamps from the Corporate Affairs Commission CAC dated 1st of March 2018, which clearly show that these documents are certified true copies with the name and signature on the exhibit. This much was alluded to by learned counsel to the claimant in paragraphs 5.5 and 5.7 of the claimant's final address. I've therefore come to the conclusion that Exhibit C3 and C4 are certified true copies of public documents are accordingly admissible. The defensive objection are hereby overruled. Exhibit C3 and C4 are rightly admitted and will be considered in determination of the rights of the parties in this one as a whole. Having pronounced upon this preliminary issue, I will now proceed to the merits of the suit. The claimant has a duty imposed upon him by Section 131 to 133 of the Evidence Act to prove his claims, and Geneva versus Afribank Nigeria PLC, Kalu versus Uzo, and Inajoko are daily citation provided for these matters. The court will proceed to consider this release period and determine whether or not the claimant has discharged his evidential burden. If one by its nature is tied to the admissibility of Exhibit C3 and C4 and the way to be attached to these exhibits, the court has determined that these exhibits were properly admitted and will be countenanced and would be countenanced. Now, the claimant insists that he was appointed by the defendant's company as he was appointed the defendant's company secretary and relied upon Exhibit C3 and C4 to establish this fact. In support of the claimant's contention are several exhibits. The defendant on his own part is adamant that he never appointed the claimant as company secretary, relying on the C1 and C2, which show that the claimant was employed as a legal officer and thereafter confirmed as such. Rather curiously, the defendant has failed to offer any meaningful explanation for the contents of Exhibit C3 and C4. There's also no other documents placed before the court by the defendant that challenges the facts contained in Exhibit C3 and C4. There has not also been argued that Exhibit C3 and C4 are forgeries or manipulating in any way. The court can therefore ascribe probative value to these exhibits and so on. I've carefully considered the reference to the claimant as the company secretary legal advisor in Exhibit C7, which is a document written on the defendant's letterhead and signed by one Olushino Dipe, the ED Ops and Admin, dated 19th of April 2016. Exhibit C9, which is also dated 3rd of May 2016. Exhibit C14, dated 4th of July 2016, where the defendant pointedly referred to the claimant as company secretary in paragraphs 2, 3, 4, and 5, and also in Exhibit D3. The defendant cannot under any guise refuse to acknowledge that the claimant was his company secretary in Exhibit C7, C9, C14, and D3. As Exhibit C7, C9, C14, and D3 corroborate the claimant's testimony as renders it more believable and as a whole. It is therefore the court's considered opinion that the claimant was indeed the defendant's secretary, company secretary, and therefore his position was one with statutory flavor, which prescribed a process for removal and as a whole. That being the case, the claimant is entitled to rely upon the provisions of the Companies and Allied Matters Act in determining whether or not his employment was validly terminated. The defendant's handbook is not the applicable document in determining the employment relationship between the parties in this case. The claimant is therefore only obliged to prove the lack of adherence to the provisions of CAMA to sections of the Companies and Allied Matters Act, which provisions provide for the steps for removal of the company secretary, which were not complied with by the defendant. What is immediately apparent here is that the defendant did not feel it was obliged to carry out the steps enumerated under CAMA and consequently ignored them. This means that the non-adherence to CAMA has rendered the removal of the claimant as company secretary as unlawful and wrongful. Relief 1 therefore succeeds and is hereby declared as paid. Comment to Relief 2. Fair hearing is all about opportunity to be heard. See the claims of Mr. James Ave and Nigeria Postal Service. And also BA Imonike versus Unity Bank, particularly where His Lordship Rosvival JSC as it then was held that accusing an employee of misconduct either by way of query or allowing the employee to answer the query and the employee answered these satisfied the Nigerian Institute of Social and Economic Research Council. Citation provided for this matter. I find that the above authorities apply here. Exhibit C7 is a query issued to and addressed to the claimant as company secretary. Exhibit C8 is the claimant's response to the query. Exhibit C9 is the lesson suspending the claimant after the defendant considered the claimant's response to Exhibit C8. Finally, Exhibit C15 terminates the claimant's employment with the defendant, making reference to the allegations contained in Exhibit C7. What the foregoing shows that the claimant was confronted with the allegations against him and gave a response. That testifies to grantable, thereby refused and dismissed accordingly. For the 3, defendant has not challenged the grant of this release, therefore taken as conceded. The 3 therefore succeeds and defendant is hereby ordered to compute and remit the claimant's pension contribution to the claimant in the sum of 2,882,353.87. Now for relief 4, I find that the claimant has not asked for reinstatement to his position as company secretary. The claimant is only asking for general damages. The position of the law as stated in the case of Transcorp Metropolitan Hotel and Conference Limited, where Shaibu JCA held that general damages are set to, well, I'm citing his lordship here. I cited his lordship here. I don't need to read it here. Now, in this instant case, it is established before this court the wrongful acts of the defendant and lawfully terminating the employment of the claimant. Damages should and ought to follow for this wrongful act, especially as the claimant here is not seeking for reinstatement. The court finds it appropriate pursuant to Section 19 of the NICA 2006 to award damages of 5 million naira to the claimant for the wrongful acts of the defendant. Relief 6 is in the form of special damages. The defendant is hereby ordered to pay the sum of 5 million naira to the claimant within 30 days of today and as order. Relief 6 is in the form of special damages. This means that the claimant has a duty to specifically claim it as with NMPC and Clifco, 7 Company, Augustus, and Mohammed Dungus was in a consortium. The claimant here tendered his payslips in proof of this head of claim. However, the court has already awarded general damages for the termination of the claimant's employment, and the employment has ceased from May 2016. In consideration of the grant of repair for payment or arrest of salary, I must refuse Relief 6 as to law frowns upon double compensation. See the case of ex-Captain Charles Ukiagu versus Nigerian Army, where the apex called that where the claimant seeks the relief of reinstatement, who relief is granted, the issue of measure of damages for wrongful termination, dismissal, or retirement becomes irrelevant because upon reinstatement, the claimant is entitled to pay all arrest of salary and emolument, including when due and payable. Relief 6 is therefore dismissed. Relief 7 is for solicitor's fees. There's nothing placed before the court in support of the relief. While it is not in doubt, monetary awards are not just made for the asking. They must be proved to the court's satisfaction, which has not been done here. I therefore refuse this refusal are unproven and dismissed accordingly. All the terms of this judgment are to be complied within 30 days, failing which they will have 20% simple interest only. Mr. Shenaki, particularly, the court had declared the first declaration as sought, right?
Yes, my lord.
And then the first declaration as sought, the pension, remittance, and then the 5 million naira as general damages. All other releases are hereby dismissed. You can pick up a copy in Lagos on Monday or Tuesday. Gentlemen?
Yeah, we must be able to your lordship.
As accomplices.
Thank you, gentlemen. There's no other counsel whose decision has not been read here, right? All the counsel on the platform, you've filed your decisions being read out, right?
No, my lord. Obinaism and EcoBank.
Oh, I'm not read that one.
That's 286/2019.
Hold on. Give me a minute, gentlemen.
Yes, my lord.
Gentlemen.
Yes, my lord.
Mr. Wumbade, you are right?
Yes, my lord.
The court had read this decision. Mr. Imosemi was in court. The court had read this decision earlier on. Yeah? Mr. Wumbade?
Yes, my lord.
Mr. Wumbade, can you hear me?
I can hear you, my lord. I can hear you.
Wumbade. Mr. Wumbade,
Yes, my lord, I can hear you. I can hear you.
Mr. Imosemi was in court earlier on when the court read this decision.
Okay, my lord, I think if that's the situation, the best I can, what I would do is probably to apply for the CTC.
No, you get it. You pick it up on Monday. Mr. Imosemi is the other counsel on the other. Is counsel on the other side, right?
Yes, my lord.
Right. Found yes, while he had this, there was no way the court was just going to award him 7 million without showing how he arrived at the 7 million.
Yes, yes, my lord. Okay.
So on that basis, the court dismissed all the reliefs. And then the court stated that on that basis, the court could, even though he was entitled to the gratuity, right? Clause 7.2 for authorize it, and then not to prove to the court that that was his entitlement. His real entitlement could be 1 million, could be 100 million, but he has not proven that. And there was no leeway for the court to even make a consequential order because the relief as couched was only for the payment of 7 million. If he had sought a declaration, right, the court would have made that declaration and then made a consequential order pursuant to that declaration for the defendant to compute and pay. You do not seek a declaration, and then the court will not now start doing the work for him.
Okay. I'm most grateful, sir. Thank you, my lord.
So you pick up on Monday or Tuesday in Lagos, please.
as conclusion. Thank you, my Lord. I'm most grateful.
Thank you, gentlemen.
Not coming cold. No, we just exit. We can leave now.
There was a matter that said defendant absent.
Yes, you can.